This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to talk about the concept of excusable neglect, which allows a party to an arbitration to dispute the findings and insist on a new trial before the court. But in Florida, to dispute an arbitration finding, the party must file the dispute within 20 days. And if it does not, the only way it can file a dispute is if there was excusable neglect sufficient to dispute the arbitration award. In Howard Roy Housen and Valerie Housen versus Universal Property Casualty Insurance Company, the Florida Court of Appeals 4th District on January 22, 2025, allowed the appeal of a final judgment in the Housen's breach of contract action. The Housens had filed an insurance claim with Universal, which was denied, leading them to file a breach of contract action. The parties agreed to non-binding arbitration, which resulted in an award not favorable to the Housens. However, the Housens who wished to dispute the award failed to file a notice of rejection of the arbitration decision within the required 20 days. Instead, they filed a motion for a new trial 29 days after the arbitrator's decision, citing a clerical error for the delay. The circuit court rejected their argument and granted Universal's motion for judgment, and the Housens moved for reconsideration, attaching an affidavit from the counsel's legal secretary explaining the calendaring error. The circuit court denied the motion and entered final judgment for Universal. A party who disagrees in Florida with a non-binding arbitration decision must file a notice of rejection of the arbitration decision and request for trial de novo within 20 days of being served with the arbitrator's decision. If the motion for trial de novo is not timely filed, then the non-binding decision shall be referred to the presiding judge, who shall enter such orders and judgments as may be required to carry out the terms of the decision by statute. The circuit court's final judgment was entered in their breach of contract action against Universal. The Housens argued that the circuit court abused its discretion when it denied their motion to vacate the judgment due to excusable neglect. The Housens argued that the late filing was due to excusable neglect, and the appellate court agreed and found that the Housens demonstrated such excusable neglect and reversed and remanded the case. Since the Housens' reason for the late filing was the legal secretary's calendaring error, it qualifies as excusable neglect in Florida. It is well established in Florida that excusable neglect is found where an inadvertent calendaring error results in an attorney's failure to act. The Housens filed their motion to set aside the judgment, attaching the legal secretary's affidavit within 1 week of the judgment's entry, and based on those actions, the Court of Appeals concluded that the Housens demonstrated excusable neglect and the circuit court had erred when it denied their motion to vacate a judgment. Lawyers, perhaps without good reason, rely on their legal secretaries to properly calendar dates that must be fulfilled on behalf of the client. Florida accepts the fact of that reliance and considers a failure of a legal secretary to properly calendar a deadline evidence of excusable neglect. The arbitration award was disputed, the judgment was reversed, and the issue before the court and between the Housens and their insurer will now be concluded in a trial in a Florida court. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. You can subscribe to the blog, and if you do, you will receive access to the more than 4,950 blog postings and notice of every new blog posting, usually 5 or 6 a week. Please tell your friends and colleagues about this blog so that they too can subscribe. They're free, and if you're interested in further detail about insurance, insurance claims, insurance fraud, and insurance law, please consider subscribing to my Substack publication. Thank you for your attention.